part of the concern is that, yes, it is true that INEC has been using the smart card reader without, so to speak, legal backing since 2015, but that in now entrenching it in the law that the smart card reader is to be used, there are fears, the fears are that in some quarters, that if that is entrenched in the law, then it leaves very little, if any, room for the failure of the smart card readers to work, something that incidentally was witnessed in 2015. In 2015, the then president, Goodluck Jonathan's biometrics failed to be recognized by the smart card reader. Those of his wife failed to be read by the smart card reader. His mother, smart card reader biometrics also failed, and that incident forms were then introduced. Now, some of the comments that have come since this bill was prepared and sent were that the issue of incident forms were not to be entertained anymore, which would then leave the problem that if the smart card reader malfunctions, if it doesn't work, if the replacements are not brought in time, then quite a large swathe of voters may be disenfranchised.
I think that INEC's practices, even without the law as we speak, has gone beyond the issue of incident forms. Now, when you calculate the total number of persons who voted after filling out the incident forms, the numbers were significant in the 2015 elections. What INEC has recognized is that people could vote even without being accredited, as long as they filled the incident forms. And when you do that, you provide an opportunity for people who may not actually even be the owners and holders of the smart card readers to vote, and that increases the incidence of electoral fraud. Now, what INEC has done is develop further software that is entrenched in the smart card readers. That means that when you have an incident that you are struggling with your PVC being recognized, there will be the backup. That means that once you are identified as the genuine holder of a PVC, the system that has now been developed means that it is now captured. You are physically captured at the polling unit, rather than a situation where once you come, it is not identified, you are given an incident form. It is further entrenched electronically that you are captured with a view to ensuring that in subsequent elections, you are not excluded. So what INEC has done has been a huge improvement on what was in 2015 and in the recent governorship elections that have been held. So my thinking is that recognizing these innovations, and it talks about smart card readers or other technological innovations, once you recognize this within the law, it means that there is a greater burden on INEC to ensure that everybody votes, and it provides further opportunity for people who may have incidents to actually vote. So I think that it's gone beyond the incidents where people could not have their PVCs identified by the smart card readers.
Mr. Nwankwo, yes, INEC has spoken about the fact that they're not going to use the incident forms, and then the smart card readers have been enhanced to ensure that everybody gets to vote when they come to that place. But then there are some who have also looked at that matter of coming there to capture again. If you identify that the card is genuine and then you capture what if the card doesn't belong to me? Because the smart card reader can identify that the card is genuine, but I might have picked it up someone. That's on the other hand. But the other matter is that question of the errors you talked about earlier, where you're saying there were not significant errors that could warrant the president refusing assent to that document. Are you not concerned that some people might have gone to court even before the elections as regards those errors in the amendment bill?
Now, I think also we need to put things in context, because a lot has been put out that is very untrue. First of all, the Electoral Act Amendment Bill takes effect from the date it is signed. If there are activities that have happened before then, such as the primaries, for instance, or any other activities that have taken place right up till the date it is signed, they will not be caught by the amendment, because the amendment is not intended and cannot be intended to have a retroactive effect. Secondly, when you litigate on an issue based on interpretation of the law, the truth is that the courts will act only on the basis of its interpretation of what the legislature actually intended. And a lot of lawyers know that there are different rules of interpretation. The courts are not going to make interpretation of the law simply based on what they immediately see, especially when there are contradictions in the law. In that case, the courts apply the different rules of interpretation that lawyers know exist. And these are very straightforward rules, and precedents have been laid for interpretation of laws. So I think a lot of the excuses given are really excuses for not signing the law, and I really, again, must say the word that I'm puzzled that the president lost a good opportunity to present himself as a reformer of our electoral process.
Well, so many things are playing out, Mr. Clement, if you will. At this point, we've had a major event that happened just yesterday, which is the signing of a peace deal between the candidates themselves of the leading political parties. Do you think that this peace deal will stand the test of time, considering that this amendment bill, the Electoral Amendment Act bill, has not been signed first? Do you think that this peace deal will suffice?
Well, it had better suffice, because I think, again, and that's why we've talked about having the Electoral Offences Commission bill, which is another bill that's been pending. The president announced a couple of weeks ago that he was submitting to the National Assembly an Electoral Offences Commission bill. This bill, as we speak, has not been submitted by the president to the National Assembly. You will have peace when people also know that there are consequences for activities that could provoke violence. And once you have an electoral offences bill in place, it means that in signing the peace deal, you will then have a supporting legislation that makes people prepared that there will be consequences for a peace deal. So the president needs to submit to the National Assembly as a matter of great national urgency the Electoral Offences Commission bill, which the Federal Executive Council announced was ready for submission to the National Assembly. But there are consequences, and we keep advocating from civil society that the incumbent, the opposition parties, all have responsibility to promote peace. In addition, and that this goes back to the ECOWAS protocol, you must not change the rules regarding elections too close to it. And this includes fundamental issues. Fundamental issues include that institutions of states must not be used to advance the cause or electoral fortunes of a particular political party. And this is referring specifically to the incumbent, that institutions of state, whether it is the broadcasting institutions of state or the security agencies or in the Electoral Commission, must not be used to advance the cause of an incumbent. These, once you respect this, of course, it means that peace reigns even deeper. And then the opposition has a responsibility not to promote hate, not to promote violence. Indeed, all the parties have a responsibility in this regard.
Mr. Clement Nwankwo, co-convener of the Election Situation Room, thank you very much for your time on Sunrise Daily this morning.